All right, everybody. Welcome to today's edition of the Leadership Blend with your host, Ricardo Rice, and my correspondent,
Simone Cherie Price.
Okay, you about to make me nervous. How about, oh God, what really just happened? All right, so today we are talking about estate planning. What does that mean to you? What does that mean to your family? Why should that be important to you? We are going to talk about all those things today. Now, as y'all know, if I want to talk about something, I go get the best of the best. So for me, who better to discuss this than to get somebody who's actually an attorney in estate planning. So we are honored to have today the amazing attorney, Alex Gaines. How are we doing today, ma'am?
Hi, Ricardo. I'm doing well. Thank you for having me.
Oh, it's absolutely my pleasure. Now, you know I have to say it, so I'm going to have to say it. So for those of you that know our friends of the show, Dr. Dana Rickman and Dr. Robert Gaines, this is Dr. Robert Gaines' wife. So that's an equal honor to have her here. Power couple. We always talk about power couples. Power couples. It's amazing.
Thank you.
All right. So, Attorney Gaines, tell us about your practice, how long you've been doing it, a little about yourself.
Okay. Well, first, I love to share that I am one of the few native Atlantans here in Atlanta. Born and raised here, and I have been practicing law. I know we're rare, so I've been practicing law.
Really?
Yeah, yeah. So get a good look, take a screenshot. Really, but I've been practicing here in Georgia for 10 years. I just celebrated my 10th anniversary from graduating from law school. I went to the University of Georgia, and I have had my own practice, Alex Gaines Law, here in Atlanta for the last 5 years. I started the practice. I'm a fourth generation entrepreneur, so that goes deep in my family tradition of starting my own business, and I had a lifelong dream of becoming a lawyer. And so everything just kind of came together right after my son was born. My first son was born. I have three little ones, a 5-year-old, a 3-year-old, and a 6-month-old. And after my first so
yeah, wow, I mentioned.
I'm never bored. I can tell you that. I'm never bored. But I started my own practice after my first son was born. I had experience in bankruptcy, consumer bankruptcy law, wills and estates, and also real estate law at that point. And I decided when I started my own firm for purposes of wanting to have flexibility with my child, but also realizing that there was an underserved market with estate planning. The traditional wills custom client is, in the golden age, the golden years, 60s, 70s, 80s, and are retiring, or maybe they're sick. And I realized that people like myself who have young kids, or people who are professionals and maybe are single and they don't have a spouse to automatically care for them if they're sick, or take care of the finances if they're unable to, that they are the main client who needs to have this information. And so that's what my focus is primarily with my firm, is focusing on informing young professionals, or just professionals and young families who have kids and need guardianship nominations in place in case something happened to them, to protect their children, about the importance of having a plan in place. Just like you mentioned, we have life insurance, we have car insurance, we have homeowners insurance even, just in case something happens. And that is what estate planning is for. It's not just about, I want to control what happens when I die. It's about how can I care for those that I love, and take care of everything that I'm already managing myself if I'm unable to.
All right. Before we get into it, because there's a lot we probably have to unpack today with this, because I really want to take us from step one all the way to the end, till you take that dirt out. So I know there's a lot that we need to unpack. So before we do that, there's too much going on in the world for us not to have some conversation. So Simone, what's on the rundown?
Yeah, good and bad, and a lot of bad unfortunately, but this week has been a really crazy week of self-reckoning for the entire country, starting from a widely circulated video that came out on Tuesday, shooting Floyd. So I think we should talk a little bit about that, a little bit about what's going on in Minnesota right now and the protests that are basically happening around the world, including in Atlanta. And then because we're still in the middle of reopening, we'll talk about COVID a little bit. We'll talk about what's safe, what's not safe, what the numbers look like. And what you probably should or shouldn't be doing, even if weather is permitting where you are. Weather is not permitting where I am right now. But there are parks that have recently done some crackdowns and folks that have started to get arrested for breaking the social distancing laws that I think a lot of folks thought were kind of null and void, or at least optional at this point because we've reopened. So I think there's probably some clarification we can do around what reopening means basically, and how to basically stay safe and also stay out of custody, considering that there are definitely still laws and rules around how we can behave at this point. So do you want to just start with George Floyd? Do you want to start in any particular order? Should we go over COVID and what's going on?
Let's start with COVID in Georgia first. Like, where do we stand with these laws? You said people were actually getting cited for stuff.
Yeah.
Let's start there.
Yeah, so very recently that started to happen. In Smyrna, there's basically a group that violated the park rules for social distancing guidelines. So Riverline Park, it's a pretty nice, pretty decent sized park in Smyrna. There was large scale activity, I guess it was continual, so they've now closed that park. It's over on Oakdale Road, and the same thing has happened with a few parks in Atlanta, including Piedmont a little bit earlier on in this process. Another Metro Atlanta city, South Fulton, has closed a park as well because people keep violating social distancing. I guess there was a football or softball training going on. So basically, even though Governor Kemp has reopened the state, his executive order states that we cannot gather in groups of more of 10 people. And we still are supposed to be following social distancing guidelines. So as businesses are reopening and people are starting to go back, I think you'll notice in some places there's a line and there's a limit as to how many folks can be in there at a time. LA Fitnesses and other big gym chains are kind of monitoring who's there. Some of them are having you check in advance so they can keep track of how many people are there. There's conflated reports about whether or not this is helping. Some folks agree that Georgia's cases are going down and that Southern cases are going down, and in Texas as well. Others are saying that, well, no, it's just the testing that's going down, and quite frankly, it's too early to tell whether or not this is an effective thing to do. But it looks like businesses and government are still trying to play it safe because Marietta announced this morning that they've canceled their Independence Day festivities. That's over a month away. So to kind of make those sort of declarations does kind of insinuate that, there's still some level of precaution around there. As of today, there have been 1,972 deaths in Georgia, 532,000 tests. So that's about 5% of the state population. About 45,000 confirmed cases and 7,800 hospitalizations. If you go to the Department of Public Health, dph.georgia.gov, you'll see their daily status report about all the different cases. You'll see those numbers as they come up. The expectation was that we would be at 2,000 deaths by June, and we are at 1972, and it is May 29th. So that is, even though the curve is flattening according to some of this research, in terms of the impact, like that death toll, that's still right on target with what public health officials were worried about. So it's kind of hard to say. I think at this point, I'm in that camp. I don't know if it's easy to say whether or not we should be open, but if you don't want to be arrested or cited, there's up to $1,000 fine and a misdemeanor, especially in cities like Atlanta or in cities, really, I think lots of different places in the county of Gwinnett. If you are found to be violating social distancing guidelines or any of those ordinances, you can definitely face legal challenges. So don't put yourself in that situation. I don't know if that's a situation where you can help, Attorney Gaines, but I think we want to discourage that anyway, even if it's something that you can jump
don't
in.
do criminal.
We don't want people in that situation, so just got to be mindful and be careful.
I think we're having issues because people are because I know myself, I think we're at a place now where people are kind of confused, and they're kind of over it. Because it's like one day, and remember how this started. You have Kemp saying one thing, you have Trump saying something else, you got Mayor Bottom saying something else. So it's just kind of like at this point, nobody's still not on one page. And, people have been in the house now for 2 months. Now you kind of open the city. And when you open the city, you kind of gave these guidelines that people really didn't follow, because a lot of these businesses that are open are not following these guidelines that they're supposed to follow to open back up. Nobody's really checking it. So it's kind of like, at this point, I'll just take my chances, because I'm going to die or I'm going to kill my kids if I stay in this house another month. So, at this point, I'm just going to take my chances. Whatever happens, happens. And I think that's kind of what we're seeing. People are just kind of over it. Nobody's controlling the narrative. And the ones that are very informed who give us the information, you silence them. So it's kind of, at this point, it's okay, I don't know what's going to happen, but the death toll is not 1 million. So I'm willing to take my chances. I understand that's kind of where we're sitting at right now. But Attorney Gaines, what are your thoughts? What do you think?
I'm actually glad that you all brought this up, because I have had those same thoughts the last few days. Like, where are we? Where do we stand? Because we have, Mayor Bottoms, who's still saying, like, everybody stay at home. We technically are allowed to go out, but we have to social distance. And then when you do go out, you see some people wearing masks and some people not. There are family, Memorial Day weekend, I'm walking my neighborhood and I'm seeing cars, down the road. And I'm like, well, they're not social distancing. So it's this weird in between. I don't even know what to call it. It's unprecedented, where we're just all over the place. And you're right, Ricardo. I think most people are saying, you know what, for my own sanity, I'm going to get out. I'm going to do something, try and play it safe. I'll wash my hands when I get home, but these kids have got to get out of the house. So I can totally relate to what you're saying. And it seems that what's unfortunate is, we don't want the death toll to go up. We don't want the numbers to go up. And a lot of this has been politicized, where we're kind of like, well, see, if the numbers go up, we shouldn't have opened. But really, no one wins if the numbers go up. We want them to come down. We also want for businesses to be able to function and not go out of business. And we want to not just write 2020 off and stay at home for the rest of the year. So there's so many things that are in play and that are at stake. And I really, really would hope that we would get some leadership on the same page, so that we can unite and we can all try and figure out a path forward for our new normal, because we're not going back.
I hate that word "new normal" though. Like this, I went into the grocery store, and I felt like I was in third world country.
Unemployment numbers.
Yeah, I'm just like, I feel like I'm in a third world country going in the grocery store, because everybody's wearing masks, and I'm just like, is this really going to be what it looks like? Mm-hmm. Yeah, and which nobody, mind you, nobody was paying attention to. I'm in, because they have the little tape on the floor at grocery store.
Yes.
So I'm on my tape. This old lady just barges into my space. I'm like, ma'am, you do realize that? Exactly. Like there's tape on the floor for a reason. Like, you shouldn't be breathing on my neck at this point. But I think my biggest question is, we keep saying that the numbers not going up or the numbers are going down, but we still haven't raised the number of people we're testing. So how can we definitively make these statements when we're not testing more people? It's not mandatory. And honestly, in my personal opinion, it's like, if I get tested and I test positive, there's no cure. So, what really comes from it? I mean, it may help the numbers, so we can be honest about numbers, but it doesn't make sense. We're not testing more people. So how can we say these statistics are actually right? Because we're not testing more people. So I don't get it. I'm sitting in the middle. I'm kind of like everybody else. I'm over it. So I don't know how that's going to play out, but there it is.
I was reading that they're encouraging every citizen to go out and get tested, and so I've thought about, well, maybe me and my family, we should make an appointment. We should get in the car and go get tested. We've been in the house for 2 months, so I doubt that we would test positive, although you can be asymptomatic and test positive. But perhaps it is on us to incite some leadership by us getting out there and us getting ourselves tested, and saying, okay, well, we feel a certain community, we've all tested negative, maybe we can do some things together. But yeah, you're right. We do need to have more testing done. 500,000.
That's a good idea.
I'm just throwing ideas out there at this point, because you can't compel people.
Yeah, it's not bad.
Yeah, it's a myth. All right, so let's move
true.
into
we talked about that
elephant
before. Also, that.
Moment to using her phone. Come on, you're going in and out, right?
So, have you? First of all, Oh no. Okay. Tell me, can you hear me at this point? Is this okay?
Yes.
Yeah.
Okay. I'll just try to talk. I'll try to talk slow enough that if it skips, it'll make a little bit of sense. In a way, we all know what's going on, and I'm sure we've seen the video or have at least are aware of it. I'm not much for those sorts of videos, but on Tuesday, the murder of George Floyd, that video started circulating. We know that, so the origin of the story was that it was a routine police call, run-of-the-mill sort of situation, but it resulted in the death of George Floyd. This was the Minneapolis Police Department. It's kind of begun a series of riots from Washington, D.C. to New York City to the West Coast. Unfortunately, that were supposed to be protests and that have become, huge situations where buildings have burned, individual homes, businesses, Target in particular, who took to Twitter this morning to vent about how frustrated that they were. And then, so initially when the video circulated, our president said on Twitter that he was going to expedite an investigation. He was going to have the DOJ look into it, that he was really disgusted by what he saw. Now, after these protests have gone the way that they've gone, he's referred to the protesters as thugs and is really dismayed about what's going on. There's always a big backlash against, protests or when as riots happen. And then there becomes this big divide about, well, the source of the frustration is really, the murder of this individual. It's not necessarily the response to that. And so why be more mad at the response than the initial problem, the initial cause? So, but the thing is, especially because I think as a nation, we are just in the middle of kind of, I think, nationally coming together, at least, on the shooting death of Ahmaud Arbery right here in Georgia and Brunswick. And very shortly after learning about Breonna Taylor in Louisville, Kentucky, being shot by police. And then there's just kind of been this series of very senseless, very callous, very calculated, brutal murders of Black people, unarmed Black people, who I think is just caused this sort of national and international outcry. Even in like London, they were showing footage of protests that was going on. This isn't even their home. It just kind of shows the impact of this and where it's being felt around the world. And so, in this case, and the reason why I'm a little, there's some small progress being made because these officers were immediately fired in a sense. Now, have there been charges brought? Is there justice all around? Not necessarily. This was an officer who had a disciplinary report before. But previously we would get language after these sorts of things like, well, we're going to do a thorough investigation and we're going to really take this seriously and we're going to be open with the public. And I feel like now they're starting to get that more swift action is required. The Sheriff's Association of the state and of multiple states have come out and said that this is disgusting. And if you have a badge and you think this is okay, turn in this badge. I appreciate people calling out their own. I appreciate law enforcement standing up for what's right and what's wrong, and us kind of deciding that, some issues, we don't need to be tribal about some issues. There just needs to be like a right or wrong and not a left or a right or whatever. But that said, there's been a lot of damage done, and I wanted to kind of open up this conversation because people have very different opinions about how things should be dealt with. Obviously, I'm a lobbyist, so I know that there are laws that we could pass that would make this country better. They would never, ever, I don't think we'll ever be able to prevent bad people from doing bad things, but there are certainly things we can do to make it a lot harder for them to get away with those things. But at the same time, people have a right to protest and they have a right to gather. So I thought we could just kind of talk about what that sentiment has been. And before I open it up, I'll just say, my dad had like a small situation earlier this week where his heart kind of like stopped for a moment, and he needed to get it kind of screened or whatever. He doesn't have those health problems, but I learned from him, I'm really stressed about this, and it just kind of opened my mind a little bit further to think, if you're older and you've seen this all before, like there could be so much triggering about, watching the sort of things happen that you used to see happen. And going back to feeling just incredibly unsafe and hunted on a regular basis. Like for those of us, who are older, for our parents and for, you know, grandparents, if we've got them left. This is not new to them, but I'm sure it's either not been on the very front of their mind, or, you know, it's something they hoped they wouldn't be going through again.
You know, and Simone, you know how I get. I think Will Smith said something that I was kind of like, he's right. I think he said that racism isn't new, it's just being filmed, or it's not getting worse, it's just being filmed. Something to that magnitude. I think we forget. I think there's a lack of correlation between what's written and what's enforced. So us dealing with what's enforced, and I'm talking about as it pertains to law. So us really, you know, getting on people about what's being enforced versus what's actually being written, I think there's a lack of correlation between that. The fact that our communities, and I'm talking about the younger generation, and it's not all of us, but it's too many of us. I don't think we really understand the power of, you know, our local government. You know, the people, the senators and stuff that are making decisions on our behalf. The fact that they are not advocating for, like what you do, Simone, with criminal reform or bills of that magnitude, they're not advocating for those types of things. What they're doing is they're kind of sitting back and going, okay, you know, I know they're expecting me to make a statement. I'll make this statement because it's what I'm supposed to do. But once this statement is over with, they're going to stop protesting. They're going to go back into their holes. We're going to continue life as normal, versus us actually standing on something, taking this energy and this momentum that we get every time we see these things and actually funneling it into making them change criminal reform. You know, I told my friend last night, I was like, you know, what we need to do is do like that episode of A Different World where they stormed the provost of somebody's office, and they actually did a sit-in in his office until he actually changed some rule that he made on campus. If we're going to protest, I think that's where we need to actually start doing it. Showing up to these senators' offices or phone calling, swamping their offices with phone calls, and not stopping until we and have some people on the front line who are in law to say, this is the bill we saw you did not vote on. This bill would have changed something in this particular community. Until you revisit this bill or re-put it back on the floor, we're going to continuously swamp your office with calls. That way, when they go back to their offices after they've made their little statement, they're having to make some form of change because they realize we're serious and we understand that you're the one that has a hand in making these laws better or worse. That's my personal opinion on it, because outside of that, you know, we have all these hashtags and we have new martyrs every other day. And I hate that somebody's life is being taken, but we have this momentum going for about 4 or 5 days, 2 weeks max, and then we go back to our normal lives until the next martyr shows up. It can't be that. You know, it has to be a two-field playing game with people on the field, you know, doing the protests and stuff, and people in these offices that are saying, okay, we have the momentum. This is where we need to divert this momentum. This is the bill that we need to be passed, or this is the legislation that needs to be changed, and we're working twofold. Because if not, we're just having more hashtags. Mm-hmm. But that's my personal opinion. Attorney Gaines, what you think? What you think?
I agree with you, Ricardo. And, you know, being an attorney and understanding the way life really works for the majority of people is you need to understand how the game is played. And for so many of us, you know, we're playing a game on social media and we're vocal, but does that voice translate to action? And as you said, getting in with the legislature, lobbying, doing sit-ins, doing effective types of protesting will affect change. And so I find it to be, the whole situation is just heartbreaking that this man lost his life, and a community is hurting. People are running on emotions and are angry, rightfully so. But in the end, I feel like that will the violence, the violence and the destruction. I was reading that one of the buildings that was destroyed was 200 units that were going to be affordable housing in the community. And so now that building is destroyed, and it set that community back. Mm-hmm. And it's taking away from the issue. But I don't excuse or condone violence and looting and breaking the law, but I understand the frustration that people have. I just agree with you that we have to come together and find a more effective way to get the change that is so needed.
I just have a question for the people. I think we're in Minnesota.
Just to close this out,
What?
Ricardo, you'll be happy to hear. What I was going to say, you'll be happy to hear that here, though, Chris Clark, who we had a great interview with, CEO of the Chamber of Commerce, he has endorsed the hate crimes bill that the House passed, and Republicans as well have hopped on that bandwagon. Chuck Abstration, who's just a good guy in general, but he as well has led this charge too. So that it's hard to, legally speaking, we don't need qualified immunity. There are so many actual laws. Citizens arrest, like, what is that? This is not 1700s. This is not ancient England. We don't need citizens arrest. So some of those things we can definitely change, but there's something to be said about the fact that when people get pissed off enough, the people in the suits behind the doors do start to sign pieces of paper. And if it doesn't seem like they have to, if that pressure isn't there, there's other priorities. We want to get people back to work. There's a million priorities. So it's kind of hard to say whether or not, it's definitely not ideal, but unfortunately that sort of pressure does seem to work, at least indirectly, before it happens here. So if you do want to get active, if you do want to storm, if you do want to be a part of the protest, there is going to be a protest at the state capitol. There's going to be a march and a protest there today. Folks are going to start meeting at 3. There'll be signs, there'll be distributable water. This is in the city of Atlanta. The demonstration at 4:20 will be held at Centennial Olympic Park. That's where it'll kind of loop back. So, if you have time this afternoon, coming up the next couple of hours, again, organizations are trying to remind people, have your ID, have an ID on you, don't destroy property, don't incite violence, obey the traffic laws, and use your cameras to record everything. That is something I've heard plenty of Democrats and Republicans say recently, and I'm glad they're saying it. So that's all.
I just, to the people, and I think we're talking Minnesota, I'm just trying to understand why we're attacking Target. I'm trying to get there. They're showing pictures of people running out of Target with lamps and mannequins, and I'm just trying to understand. I don't get it. Look, I know there are opportunists who wait for these moments to get that big screen TV they want, but come on, people, we cannot destroy the stuff in your community. Once you destroy that Target, there's no guarantee that Target is going to build back in that same community. So let's be smart about this. Let's not be crazy, and let's not use the opportunity to decorate your house with the lamps you just felt like you couldn't afford from Target. Let's be smart about this. But I digress. All right, so let's get into the matter of today. We've had a nice little conversation, but let's get to the real conversation. So we're going to talk about estate planning. What is that? Why do I need it? All that good stuff. So we have the amazing attorney on the line with us today, Attorney Gaines, Alex Gaines, who has her own practice. So let's start from ground zero. So Lawyer Gaines, Attorney Gaines, tell us what exactly is probate and all these things. What does that stuff actually mean to the average person? What does that mean?
Okay. Estate planning, probate, all these terms don't matter to anybody until they matter because there's been a hospitalization or a death or something like that. So we'll start with just some vocabulary. Okay, probate is the court that has jurisdiction over certain matters in our state, such as when someone dies, primarily, what happens to their property, how does it pass to them, or guardianship. If someone becomes permanently incapacitated, they are in a vegetative state indefinitely, and their family elects to keep them on life support, but they need someone to make their medical decisions. They need someone else to take care of them. Well, there has to be a legal mechanism to do that, and so you go to probate court. So probate is what happens when you need to get authority to manage the affairs or the property, transfer the property of someone who has passed away or has become incapacitated. Estate planning is what we do to avoid probate, essentially. What I counsel my clients to do and educate the public on, I hold regular seminars on estate planning, is putting your own plan in place so that you're not subject to the state's default plan for you, for everyone. Because it in many instances is not what you would want to happen. For example, I have a client who is estranged from her father. Her mother is deceased. her father, she's unmarried, doesn't have any children, and her father is her legal heir. He's also her default decision maker if something happens to her. So she has realized that upon speaking with me, and she's like, oh my gosh, that's scary. I need to get something in place. So what I do is I help you utilize different documents, different strategies to make sure that if I am incapacitated, meaning I'm alive, but I cannot pay my own bills, I cannot make my own medical decisions, that you have empowered someone else to do that legally, and you have given them instructions, and also you set them up so that they are not having to go fishing for your important information to be able to manage your affairs while you're incapacitated. So COVID is a perfect example. COVID-19 has, had thousands, tens of thousands of people hospitalized, and we know the deaths. So that's a separate issue. But for those of us that will recover, that were on a ventilator, but for those 2, 3, 4, 6 weeks that they were unable to do the things that we normally do, such as just go to the bank or, make sure my mortgage is paid, take care of my children. If you have minor children, you need to have a couple of things in place, a few things. One, you need to have, and Ricardo, let me know if you want me to stop so you can ask some more questions. I'll tell you what documents we need. Keep going. Okay. For incapacity. So, we don't want to jump all the way to death, because you're 9 times more likely to become disabled or incapacitated for temporarily than you are to die prematurely. Okay. So estate planning talks about, what if I'm alive, but I'm not able? Okay. So you need to have an advance directive for healthcare. That tells, it empowers another person that you trust, and it doesn't have to be a family member. It could be, a friend who is a nurse or is in the medical field, or who you just trust to make the decisions that you would want them to make, to be your healthcare agent, and to, get you into rehabilitation if you need to have some physical therapy, or if you had a brain injury, those types of decisions that need to be made. You're empowering an agent to do that, and you're giving them instructions on the type of treatment you want. So that's one portion. And then the other portion is a power of attorney, a durable power of attorney that authorize a trusted and responsible. Those are the 2 qualifying characteristics: trusted and responsible person to manage your money and your property. So your home, your car, even, file your taxes, because even if you're incapacitated, you still have to file your taxes or sign for your mail, check your email, and log into your online banking. All of these things that, if you're not able to do them and you have not given someone a power of attorney, will result in the probate court not taking over, but you having to go through the probate court to get these things, to get authorization to do these things. So we're avoiding that by having a power of attorney.
Question.
Yes.
All right, so let me ask you a question. When we talk about power of attorney, is that just a form, or that's a subdivision in a will that says before death, if something happens, if I become incapacitated, that this individual assumes the power of attorney? Or is that a separate document that you can do just on your own?
Good question. And there's a lot of confusion around that. A power of attorney is only effective. It is a separate document. It is its own form, and it is only effective for someone while they are living. A will is a completely separate document that only comes into effect at death. So you can have the person in charge of your will that you've left over that is called the executor or executrix if it's a woman. And that person, you could have a will that is just like, completely detailed and laid out. I want this to go here, and he can manage that. It does not matter if you become incapacitated, okay, because you're not dead. So your power of attorney is a separate document that is very important to have for the period of time prior to you passing away. And at death, it is completely void. It is no longer effective, the power of attorney. At that point, your will takes over, but the will has to be filed with the probate court and approved by the probate court. And you have to give notice to an individual's heirs about that will before your executor can actually take authority over your property. And it's not an overnight, and it's not an automatic thing when you have a will.
Okay, so with the power of attorney, is that, because I know with the will, you definitely should have a attorney involved. With a power of attorney, is that a standard form that people can just kind of get that has standard language in it, or does it have specific language that goes to your situation?
That's also a good question. And being an attorney, I'm going to tell you that you need to have an attorney in preparing a power of attorney. But I will say there is a standard form. There's a statutory form that you can find. If you're resourceful, you can probably find it online. But the reason that I would recommend having an attorney at least assist in the execution of that is that there are certain execution requirements. You have to have a witness, you have to have a notary, you have to check certain boxes or initial if you want to give the power of attorney, your agent, certain powers, or if you want to limit certain powers. And so while there is a standard form, and if you are a person who reads thoroughly, you can probably, take care of it yourself. But in my experience, people overlook so many things in this, 15-page form. The power of attorneys that I prepare for my clients are about 22 pages. And so of powers. And I have to make sure that my clients know, several powers. We try to cover everything, because if you don't cover and account for it, then the state statutory laws do. And again, you don't always know that will be what you want to happen.
Okay, so let's go forward with two different scenarios. So let's talk about a scenario that does not have a will. And actually, before we get there, let's because I want to dispel how people think. Because the thought process is, well, if I'm not rich, then why do I need to have a will? Right. Because what do I have to leave to somebody if I'm not rich? Mm-hmm. So let's get into that first. Like, what are the kind of things that people, I'm sure everything, but what are the kind of things that the average Joe would probably possess that they should have a will to kind of execute after their demise?
That's a great question. You're asking wonderful questions, Ricardo.
Well, I'm a law nerd. I probably should have told you I'm a law nerd. I just go to law school, took the LSAT, and didn't go. So I'm a law nerd.
Well, it's never too late. It's never too late. So there's a lot of misconception about why you would need to have a will or have an estate plan. And I've already talked about why you need to have a portion of the estate plan, the incapacity plan. But as far as what you need to have, just take a moment and think about, do you own a house? Do you have a bank account? Do you have retirement of some sort? Do you have life insurance? If you have just any of those things, you have an estate, and that is why you need to plan for it. So it doesn't matter how much it is. In fact, the less that you have, the more you need to be really picky about where it goes, because you don't have as much as someone who's rich and can, it can be split. But more importantly, it's about the people that you love. If you are married, if you have children, it is crucial that your life insurance has the right beneficiary. It's also vitally important that you have made a plan for the funds that would be left for your spouse or for your children or anyone who's dependent on you, if you have an older parent who is dependent on you. And so you need to have a will for that, because if you don't, there are a number of scenarios that will leave your family in a worse position than they were than they would otherwise be. For example, if you have a minor child and you've left your life insurance policy, so you said, I don't need a will because all I really have is, this $250,000 life insurance policy, and I left it to my kid who's 12. Well, the law says that a minor cannot inherit or manage any assets that are over a certain amount, and that threshold is $15,000. If it's over that amount, then it will have to be held in a conservatorship for this minor. And the conservatorship is through the probate court. So that means that, let's say it's New York Life. And New York Life has said, you know, there's a policy for $250,000, but we cannot release this money to you, you know, auntie, who's the child's auntie, who's now taking care of the child, because this child is a minor. You have to get approved by the court to become this child's conservator, and that just means that you are managing their property until they turn 18. So not only do you have to get a bond for that $250,000, and it's based on your credit score, it's based on your financial history. You have to pay for that bond. You have to file annual inventories and returns with the court. So you're under the court's regulations and rules, and you can be held, you know, personally liable if you don't handle it properly. And then when that child turns, and you have to come up with a written plan for it to say, this is where we're going to spend the money on. So it can be very burdensome, the administrative portion of managing that money for that child, and expensive. And then at the time the child turns 18, you have to hand it over to them. So let's say there's, you know, $200,000 left. You have to give that child that $200,000 at 18. And how many of us would feel that like that was a good idea, to receive a windfall like that at 18?
Yeah, no.
No, it's not a good idea. And so I've had clients who their children literally could not even get access to the money because no one could afford the bond to pay for it. It's you know, if it's $1 million policy, or however much, whatever the bond is what you have to pay. Or if there are multiple children, you have to get a bond for each child's portion. So that's just one example why you need to, first of all, never put your minor child as a beneficiary of life insurance. And secondly, have a will, or one thing we haven't talked about, Ricardo, and that I'm a big supporter of, and I encourage clients to look into it, is a living trust. I don't know if you're familiar with that, but having a living trust for yourself allows you to bypass completely the probate court, and you have, you know, your life insurance, your retirement, your financial accounts, investment accounts can all funnel into your living trust, and you appoint a trustee to manage that money and that property. If you have a home that you want, you know, your children to stay in until they have married or whatever, then you can put that in your living trust and have your trustee manage it for them until they turn whatever age you're comfortable with. Most of my clients, you know, don't want their kids to be able to start getting windfalls until they turn 30.
Okay, so let's stay there. Let's stay there with ways that you can bypass probate court, that you and your attorney can make decisions, good decisions, because in essence it's your assets, good decisions to distribute it. So you talked about a living trust. Explain that a little bit more, and any other things that you can do, set in motion, that will bypass probate court.
Okay, so with your living trust, you are creating it's basically a contract. Trust, there are different types of trust. There are revocable trusts, there are irrevocable trusts. And, you know, a lot of people say, well, I don't have much to even need a trust, but it's not so much about having money that you want to, you know, protect from taxes and things of that nature, but it's about just controlling it and making it an easier transition and a smoother transition for your beneficiaries. So the living trust is just a contract between yourself, who you're the grantor. For example, my husband and I, we set up living trust. We set up a joint living trust for ourselves, and our life insurance, our retirement, our home, all of those things will be a part of that trust. If Lord forbid something were to happen to both of us, we've got 3 kids under the age of 6. So the living trust, we are the trustees of that trust, so that while we're alive and able, we manage our property the same way, you know, anyone else does. If we want to sell the property that's in it, we can do that. It's just a matter of signing your name as trustee. So we've transferred those assets into the living trust, and we are the trustees of that trust. We're also the beneficiaries of the trust while we're living. So nothing changes in how you have to operate with the living trust, except for a few minor details about how you sign your name. Okay. So once it's established, you've already listed within that trust, and our trust is probably about 75 pages long. It accounts for what happens if if one of us becomes incapacitated, then the other is automatically able to manage all of the rest of the property. And this is important for clients who might have who aren't married and have a partner, or they have they live with their sibling. They bought a home with their sibling, and so their sibling is not. No one is automatically authorized to manage your affairs, particularly with the mortgage. If you're the only person on the mortgage and your spouse or the other partner that you're living with is not on the mortgage, if something happens to you, your trustee is able to manage, is able to still speak with the mortgage company and do modifications and refinance and things of that nature if you have a trustee.
All right, let me ask the question real quick.
Yes.
Let me ask a question real quick.
Mm-hmm.
So, and I'm gonna feel real proud when I say this. So don't shoot me down if I'm wrong.
Okay.
So when we talk about spouses, because the example of you and Robert is a good example. What role does, let me see, what is it? Because I had to take this in my paralegal program. Joint tenancy with right of survivorship.
Mm-hmm.
What role does that play as it pertains to things passing to the other spouse and the demise of the other spouse? What role does that play in all of this?
Okay, that's a great scenario to talk about. Joint tenancy with right of survivorship is a way to own property, particularly real estate. And it just says that if you have multiple owners, particularly, usually a husband and wife or spouses, and one of them passes away, the survivor is automatically the owner of that property without you having to go to probate or anything like that. And that's great for many instances, many couples. But what happens if that spouse, that surviving spouse, then remarries, or they have more children with someone else? And so this house that you've built, that you and before that spouse passed away, you bought a house, let's say it had $200,000 equity because you lived there for several years, and you've got children who are now 15. And then this surviving spouse remarries. They put that house as joint tenancy with right of survivorship with their new spouse, and then they pass away. Well, now we have a scenario in which your children from a previous relationship are now unintentionally disinherited from this house because you put your new spouse as the owner. Or let's say you didn't even put them as a joint tenant, that you just remarried and then you passed away. Well, then now this surviving spouse, the new surviving spouse, is a joint owner with the children, and it has to go through probate. So joint tenancy is a great thing in some scenarios, but you have to think through it. So alternatively, clients can put their home into their living trust and then say what happens with that house when they pass away. So the surviving spouse can have it as long as they're alive and they don't remarry. And when they pass away, then that house is going to your children. So it just protects your beneficiaries.
I have a quick question along those same lines though, Ricardo, and it may add like an extra layer, but when I worked in a financial planning office, one of the clients' concerns was always the kids getting remarried. Like they wanted to break up the money into thirds, and like the kid when they were 18 could get this much, or 30 could get this much, etc.
Yes.
But it was like, if they're married, everything goes to the grandkids basically. Like they were immediately thinking through, they do not want whoever their partner's children to be to get, and I was confused about that only because I thought that if you had a prenup, if the kids got prenups, you wouldn't have to, like, how does that impact it? Because you would think, okay, they want everything going to their blood and their bloodline only, essentially.
Yes, the bloodline. Yeah, absolutely.
Right. But if their kids have a prenup, doesn't that protect it too, or not necessarily? Like,
well, it depends on the terms of that. That is an extra layer, and that's more family law. But the terms of the prenup really, it depends on the terms of the prenup. Also, if you marry but you have not, and let's say you don't have a prenup, or the prenup doesn't account, it only accounts for the assets that you have at the time that you get married. And you then later inherit from your parents while you're married. So that brings in, it makes it, is it marital property? And so
Gotcha.
that's why people will say, you know what, we're skipping over them. We got them to adulthood. They have jobs. And I can tell you that 99.9% of my clients want to keep it in their bloodline unless their child is already married and they know who their child's spouse is, feel comfortable. They don't want to take the chance of it being lost in divorce.
Yeah.
See, this is why when I had my paralegal classes, we had different classes in different aspects of law. This was my least favorite because it gets complicated so fast. Like it gets complicated so fast. Like even when I took real estate classes, like when we got to this part, there's like joint in common, joint. I'm just like, oh my God, I commend you for doing this. All right, so let's keep it from being complicated because I want to keep it real simple for the average Joe where we're at. So let's look at a scenario that has to go through probate. What are some of the laws in place as it pertains to probate that they should probably be aware of, if with or without a law? I mean, with or without a will?
Great question. So if you are married, let's say, if you don't have a will, then the laws of intestacy in Georgia are such that it's going to say if you're married and you don't have kids, then your spouse gets 100% of your property, whatever that property is. Okay, if you're married and you have children, let's say you have one child, then the spouse and the child will split your property 50-50. Now, of course, that brings in a whole nother issue if you have a minor child and a spouse, because then you've got a minor child that's now, that's an heir to a $400,000 house. Again, that minor child's portion will have to go into conservatorship. If you ever wanted to sell that house, you have to get the court's permission to sell that child's portion. So it's breaking down the percentages. So if you've got children and a spouse, then your spouse is going to get at least 1/3 of your estate, and then we'll have to split it with the remainder. Your children will have to split the remainder. If you're not married and you don't have children, then your parents are your sole heirs. And for those who have parents that, they're estranged from, or who are elderly and who are on Medicaid or on some type of government assistance, well, you need to account for the fact that inheritance could affect their qualifying for government assistance. So without a will, you could, they're receiving something, but it could actually affect them negatively because they may not qualify anymore for the assistance they're receiving. And so without a will, they're just default laws, and you can go and look at the statute and it'll tell you who gets what. And so it's going to keep going down the line looking for heirs. If if you don't have children, you're not married, you don't have parents, then it's going to siblings, and it will just continue and continue. And it just says it splits it based on the number of siblings or family members within that tier of family.
Okay, so we're talking about,
I will say additionally, if you don't have a will, well, then someone has to qualify as the administrator to actually distribute your property. And so that brings in a whole nother scenario, because there isn't anyone that automatically will qualify. They have to petition the court, and anyone can petition the court to be the administrator over your estate if you don't have a will.
Ooh.
what do you mean anyone? Like somebody walk off the street?
Anyone, and can make the case that they, the law will take into consideration whether you had a relationship with this person, but anyone can petition to be.
But imagine siblings. I'm sure this is a siblings thing, like
Yes.
all the time. Like I'm the oldest, or oh wow, that just sounds messy.
Messy, very messy.
Can I ask one quick question, Ricardo? It's on the healthcare track, because you talked about what happens if we don't have a will, but the healthcare directive was always very important to me. And I think the second I found out about one, I started that process, and now it's been a while and I should probably revisit it. But if you would become a vegetable, like a worst case scenario situation, I think I was thinking about this because in Oregon, there are euthanasia laws. And I started thinking, well, in Georgia, like imagine if you're in a place where doctors feel like you're probably never going to have a functioning brain or body again. And what happens? Like there are some people, who have this is kind of where like your beliefs come into it. Like, do you believe in pulling the plug? Or, does the husband want to pull the plug and the kids don't? Or do the kids and the husband doesn't? Or vice, those are the questions I started asking. So I was like, that seems like a really important thing. And I don't know if a lot of people have healthcare directives, and I don't know what happens if you don't have a directive.
Yes, I have in my seminars, we talk about this. I created a fictional family in which the wife gets injured. She's in a vegetative state. Doctors have said they don't think she's going to wake up. The husband wants to keep her on. The children are saying she would never want to be kept alive this way. And so what happens? Well, first, the law says that if you're married, your spouse is your decision maker. So he can keep her on life support as long as, you know, they can afford to keep her on. And so you should absolutely have an advance directive if that's something that, and you should have the conversation. That's something else that we just need to have these conversations, speak hypothetically. It does not have to be morbid, but just present the scenario. So when I meet with clients, you know, step one is to give them all the information. And then step two is our design meeting where we actually talk through these scenarios, and you had the, you know, you started to talk about it with your spouse or whoever you want to be your agent and say, this is what I would want. Are you willing to do that for me? To, you know, alleviate the burden of someone else having to make the decision of taking you off of life-sustaining treatments, and tell them what you want. Put that in your documents, and it makes such a difference for your family to know that they're not, you know, killing their loved one. They're doing what they wanted them to do, which is just allow for nature to take its course. So you're taking them off of, you know, this artificial life-sustaining treatment, and then allowing their body to do what it's going to do. So you can look at it from that scenario rather than it being, you know, a euthanasia or something like that. But it's absolutely important. And typically clients who are, you know, our older clients, 70 and up, once they go to the doctor so often, the doctors are asking them, do you have an advance directive? And that's usually when that conversation starts to take place. But it should be a conversation that all doctors have with their, and individuals have, to make sure that if there is, you know, an accident on 285, that you have already thought about that scenario. And most of the time clients will say, you know, give me 3 to 7 days, or give me 30 days, give me 60 days, or, you know, leave me on until you go, and we'll go together. But that's really your decision, and you should give that guidance to your loved ones so that they're not, it can, you know, it can tear families apart, as you mentioned, if the spouse wants something, the children don't, or if you don't have a spouse and it's just your children who are arguing over it. If you aren't married, you have adult children, all of your adult children have a say. So it's decision making by committee from that point. And we know, you know, when emotions are high, it's the potential for conflict is just out, you know, it's off the charts. So we want to avoid all
Okay,
that.
so let me ask this question. How different do the laws vary and defaults across state to state? Like, is each state drastically different, or is there like a core of laws that are almost the same, varying from state to state? Because there are different people listening and watching who are not in Georgia. Right. So how vaguely different are the laws from state to state?
That's you know, there is a uniform law. There are what we call uniform laws, in which all of the states will get together, or attorneys from several states will get together and say, just across the board, these are, you know, the baseline rules and scenarios, and states can choose to follow those. And they will adopt them. So that's the case with, you know, with some guardianship, with guardianship laws or minor. So generally you can say, aside from Texas, New York, and California, that most states will have, and Louisiana has its own set of laws. Most states will have something similar to what I've just talked about, but I'm not licensed. I'm only licensed to practice law in Georgia. So this is legal advice if you are not in Georgia. You got to put that disclaimer out there. So typically you have intestacy laws that are similar to what I've described, where it goes, you know, spouse and then split between the children. Those are pretty similar. You know, as Simone mentioned, Oregon has very different laws about end of life preferences and decisions. So, you know, there are different states that are more nuanced. So you definitely want to refer to if you can't get an attorney, just refer to legal aid, or just Google, wills or advance directive in this state and see what you find. There's a lot of free information out there for anyone who's looking to get more information about what they need in their state.
Okay, last question before we get to the wrap up, because we're over time, but you're so good. I feel like people really need to hear this stuff. What are some things you cannot will? Because I don't think people understand. There are certain things you probably cannot leave in a will to any individual. What are some things that you cannot will?
Well, you cannot will a person, a child. You have to have separate guardianship nominations for your children if they're under 18. And so you need to account for your children if you have them. You can will a pet. You can will a pet as considered property. You can also leave money to your pet. I'm drafting a pet trust this week. This pet is going to receive a good portion of the estate. I mean, a good 25% of the estate.
Okay, so wait. Pause. Little Whiskers cannot spend money. So how does that work? Like, I wonder that. How does that work?
Is that more of like a symbolic thing? Like, is that kind of like a middle finger?
No, well, you could call it a middle finger, or you could call it they are leaving their assets to the one who was there for them, the one that was their true family when other family members weren't. But what it does is it says that my home, my money is going to be used for the benefit of my pet. So you appoint a pet trustee as well as a caretaker, and they don't have to be the same person. So for example, I've had in the past client who had a very nice home and said the caretaker can live in the home as long as the dog is alive. As long as she's caring for the dog and the dog is alive, my home is for the benefit of my dog and the caretaker. Once the dog dies, then the house should be sold and the remaining of the funds will be left to, the Humane Society. Or, the pet is to be, they should have this type of food. They will be groomed this often. They are to have, the pet spas and different things, whatever they will eat beef. And so I'm leaving $50,000 to make sure that my pet is taken care of. So.
Oh, good Lord. Okay. One of the last few questions.
Mm-hmm.
Oh, go ahead.
Oh, just to answer your question, the things that you can't put in a will. Most things will go through your will if you put them there, except for individuals, as I mentioned. But if you have beneficiaries on your life insurance or on your retirement, those supersede your will. So a lot of times people will choose their beneficiaries when they first start working somewhere and forget about it, and then they put something else in their will. The will is not going to control that. It's all about what the beneficiary is. So if you've got some things that you haven't looked at in a while, you need to go check it out, your beneficiaries, and update them consistently.
Okay. Next to last question. Time frames. So if I have a will versus if I don't have a will, what's the time frame difference? Because I know that if you have a will, it makes things easier. The execution of the will can kind of have authority to execute what's in the will. Mm-hmm. And I don't really think you have to really touch probate court per se. If you don't have a will, how does that searching process, how long does that take? Like, what is the time frame difference?
Well, I think the better comparison would be if you have a will or don't have a will versus if you have a trust. A living trust is what I would say, Ricardo. And here's why. Even if you have a will, it follows the very similar protocols as not having a will. It's just that you have the control over who is going to be going to court and who's going to get your property. So the time frame is still very similar, whether you have a will with an executor or you have no will and there has to be an administrator appointed. Of course, the scenarios are different depending on your family situation. If you've got, half siblings, I have a client who had half siblings that were 40 years older than him, and he had a will, but it held up because in his will left everything to someone else. But because he had half siblings, they were considered his heirs. And even with the will, you have to give notice to your half siblings that you haven't spoken to in decades. So that held up the will by 9 months, us being able to get the executor approved, because we had to go find these heirs, and then somebody died. One of the heirs died, so we had to go find their heirs to give them notice. So that time frame is still very similar, but the difference is that you have chosen who's going to be the executor and who's going to get the property, how it's going to be divided. That's the big difference there. Time frame is still similar, and it's usually, you know, anywhere from 6 to 12 months for probate if things go smoothly. If they don't go smoothly, it can be years to get everything sorted out. Now compare that with the trust. You don't have to go through the court at all. You've already chosen your trustee. You don't have to give notice to heirs. You're only giving notice to beneficiaries. It's more 3 to 6 months of transferring everything. So it can make a huge difference. 0 to 6 months, I would say, depending on what assets you have.
All right. Well, I don't want to take up any more of your time. I know you have 3 little ones, and you got stuff to do with them. All right. So how do people get in touch with you? Actually, wait. Before we do that, people tend to remember steps. So I always get the guests to give steps. So if somebody listens or was watching today and had not previously been thinking about any of this stuff, and now they're like, you know what, I need this stuff. Give me 3 steps that they might want to take to start this process or to get things moving.
Okay, great. Well, what we always say is that we want, for our clients with Alex Gaines Law, we want the process to be easy, efficient, and enjoyable. So I can tell you what the steps are with us. Is the first step is to schedule an education meeting. And these days they're all done virtually. So it's an hour to an hour and a half where we will give you all the information you need in that conversation to decide whether you want a will, whether you want a trust, and what you need for yourself. So that's step 1. Schedule that. We have that. Next step would be for us to actually design and draft your plan. We'll sit down. We'll tell you, you know, what things you need to be thinking about. We'll give you a questionnaire to fill out and tell you who you need to talk to. You know, have the conversations with people that you want to be your guardian for your children, or to be your executor or your trustee. Have those conversations, and then we take care of everything else. We draft it up, we upload it to you electronically so that you can review the drafts from the comfort of your own bed at night. If you need some reading material at night, you review the drafts, and then we schedule your signing meeting. And that signing meeting, we call it, it's a signing ceremony, but it's a celebration. So we have, you know, our sparkling cider. Well, we used to do that before COVID-19 came into place. We would celebrate you, and you come sit down and you sign these documents and you're done. Okay. And there's one piece I didn't mention in this, because we're more so focused on the fundamentals, the basics. But there's a last piece, and we call it the legacy transfer. And that is where we give you the ability to do a legacy video or legacy letters, so that you are memorializing your story, your advice for your children or for your loved ones, and telling your story. And so that's the legacy piece. That's why my firm, we nicknamed ourselves the Legacy Firm, because we want to help you secure your legacy for yourself and for your loved ones, for generations to come.
All right. So how do people get in touch with you?
You can go to @AlexGainesLaw on Instagram. You can go to facebook.com/AlexGainesLaw. And you can go to www.alexgaineslaw.com to schedule a consultation.
All right. Any thoughts you want to leave with the people before we end it up?
Yes, estate planning is oftentimes avoided and is not talked about. But I promise you, I've never had anyone, people think that when they sign their will or their trust that they're going to die, that they're going to bring it on against themselves. And I've never had that happen. But I have had over and over again people who said, I'm going to get to it one day. I'm going to finish it one day, or I'll get to it. And they passed before they could. And their family was left, trying to pick up all the pieces. And so I just encourage you to have the conversation, because you're doing this. Yes, you're doing it for yourself, but you're doing it for the people that you love. And I promise you, it's not as bad as you think it is, especially if you work with us. I pride myself on having clients at the end, once they sign their documents, say, I really enjoyed this. And I hope that will be the case for every client that I have. And if you go with another attorney, just find someone or go online and get something in place for yourself.
All right, Simone, anything further?
No way. That was just really, really monumental advice. And you don't want to be afraid of those conversations. It's something I've have to deal with my own dad, who I love very much, but he just thinks that the second he puts some paperwork in place, the universe is going to answer and make sure that they get taken care of. And no, that's a really good message. So,
yeah.
All right, everybody. So there you have it, Attorney Gaines, for being here today. We want to thank you because I could have kept going. I had like 50,000 other questions that I really could have kept asking. I'm a law nerd, and there's so many laws and so many things to talk about when you get into probate. So you definitely have to come back again so we can do a part 2 and really dissect some stuff. All right, on Monday we have the amazing, I call him Generational Z, speaker Jared Sawyer Jr. will be here. And next Friday we have, go to the website. I'm not trying to remember this stuff. RiceCommunity.com, Rice with a W. I'm not trying to remember this. Rice with a W, so Rice, WRICE community.com. There you can find out all the information, all the guests, all that good stuff. Until Monday, we will see you then. Everybody stick around. You guys stick around while I do a live stream. All right, everybody. We'll see you later.